Okay, so we are talking about unintentional tort for this next chapter. You've hopefully already read this because you did a discussion on it, but I just wanted to reiterate a few things and just get you guys updated. Alright, so tort, basic info. When you hear the word tort, I want you to think wrongful act. Alright, intentional, unintentional, wrongful act. So we are going to start by talking about unintentional torts. Alright, so not on purpose, but tort definition right here. Intentional or unintentional conduct that amounts to a legal wrong and causes harm for which courts will impose civil liability. So punching your brother, not in that category, okay? So courts will impose. That's got to be involved. And we'll talk about what factors are involved to make it get to that level. So negligence. This is the number one example we have of unintentional tort, okay? So a tort which the alleged wrongdoer does not intend the consequences of his or her actions to another person, property, or reputation, all right? So this is somebody usually didn't do something that they should have, or they, put something, maybe some equipment in a weight room, put it in the way, or maybe didn't think about in a school setting something that could be dangerous to kindergartners, and so they set up shelves where kindergartners walk by it every day, and kindergartners can hit it, and potentially that could fall over. That's negligence, just not thinking about, okay, what's the best way to do this to protect all parties involved. So we can break down negligence into two categories. So omission versus commission. All right, so omission is the failure to act. All right, so this is something that you clearly should have done and you didn't do. This scenario, and there's a big old long definition here for commission. And I'll read it. Commission of an act is one that a prudent person would not have done. All right, if a person could have prevented an action from occurring but chose not to, it would be considered an act of omission. So like if you see a super icy section outside of your business, a reasonable person is going to say, okay, I'm going to put salt out there. I'm going to put up a sign that says, watch for ice, things like that. So that's a prudent action that just makes sense to do. And omission is an act of one that a prudent person would have fulfilled resulting in damages. So this is a prudent person. This a lot of times is what medical professionals could get in trouble with. So some of you future PTs, watch out. Is there's somebody, maybe having a heart attack and needs CPR, and you just walked by and didn't do anything about it. That would be one of those scenarios where it's an act of omission, where you should have done something and you didn't. And you just avoided it. So negligence can sometimes be a really great case on negligence is a coach participating in tackling drills with a middle school team, showing them how to tackle. All right, so that could potentially, I guess you could say that's assault and battery, but more so it's negligence because that's not a wise way to coach. Like a prudent person doesn't say, let me tackle some 12-year-olds, right? Not good. So those are some examples of negligence. You're not going to be like quizzed on the difference in omission and commission, but just letting you know. But mainly is just doing something or not doing something that a prudent, reasonable person would do is our main example. So there's a few types of negligence. I'll let you read through these. It's not crazy important that you know the difference, but it's basically sometimes you can be negligent, but also the party that gets injured, maybe they did something dumb too. So a lot of times, maybe you were negligent, but also they should have been able to say, oh, like maybe I shouldn't do that. Maybe I shouldn't put myself in that situation. So sometimes it's like 50-50, the defendant, the plaintiff, who's at fault, and they kind of divvy up maybe the compensation owed to the plaintiff. Okay, yeah, the defendant was 75% at fault, but there was still some fault by the plaintiff. That's usually how it's broken down. So these are just some ways that you can compare how much fault is involved for each party. I think that covers that. And then these are the 4 things that you have to have for it to be negligence. Okay, so think about this. A duty was owed to the plaintiff. We'll talk about duty a little bit more in a second. So a duty was owed to the plaintiff. The defendant breached that duty. So they did not do what they were supposed to do. The breach of duty was of proximate cause or legal cause of the plaintiff's injuries, and then the plaintiff suffered damages. So we're going to talk about this word, that word, and this little phrase in the following slides. So after you go through those, you may want to come back to this slide. So, breach of duty. A duty is a special relationship between two or more parties that may be created by a statute, contract, or common law, okay? So a coach-player relationship. Sometimes common law, there's just certain expectations of a coach, but sometimes there's actually a literal contract involved in that relationship. And sometimes with maybe a principal and a teacher or superintendent, there are certain expectations. Some are written in a contract. Maybe you sign up for a local wellness center or gym. There's certain expectations in a contract of what's going to be provided to you and what's going to be taken care of. And those words create that relationship. Now, also there's times that sometimes there's not a contract. Maybe you play ultimate with a group of guys on Saturdays, and it is outside of normal expectation of ultimate for there to be punches thrown. So somebody goes and throws a punch, that is not within the general expectation, but that common law is, hey, this isn't something we usually do, all right? You don't necessarily have anything written in the rules of pickup ultimate, but it's kind of an expectation that you have that you're not going to get punched. So hopefully that kind of explains those. Breach of duty if a judge or jury determines that a reasonable person in the position of the defendant acts negligently, okay? It's a case-by-case determination. Very rarely are these the exact same scenarios. Nice little definition for you, but there's a breach of duty. Somebody did not do what they were supposed to do. And we'll talk about specific duties at the end of this section with coaches, administrators, referees, etc. So sometimes negligence is so bad that it could potentially be considered gross negligence or willful or wanton misconduct. So a good example of this that thankfully didn't fully happen, but we always want to think with negligence, like what would a reasonable, responsible person do? And for you, going into your future careers, working with kids, working with injured people, working with athletes, you've got to think about these things, all right? Because you're at higher risk, because people are playing, injuries are already going to be more involved in the future careers that you all have. So you've got to think ahead on these things. So an example that I can think of is one that we actually had to deal with a few weeks ago at an away game. And while my players were shooting, they were like, Kylie, look at those rims. They are bouncing everywhere. And sometimes you go, like there's loose rims, whatever, but these were actually, the rim would move when somebody switched a shot. And to me, I was just like, what on earth? How do you not tighten that? Because if a rim is that loose, for women it's not that much of an issue, but men dunk, okay? And they put their 200 pounds of weight on that rim, and this rim is just bouncing around. So it wasn't a good situation. When we go in the locker room at halftime, the men come out and warm up. And while one of our Milligan men was going up for a dunk during warm-ups, he actually ripped the rim off. And the rim came down. Thankfully didn't hit anybody. Thankfully he didn't get hit in the head with the rim or injure himself in any capacity. But to me, this is one of those that I kind of see as gross negligence. All right, now thankfully nothing happened. No one got sued. No one got injured. But to me, I looked at that rim and I said, that's a problem. As a coach, I said, that's an issue. But I'm not responsible for another team's facility. And so in that situation, especially if our player for Milligan had gotten hurt, man, we would have had a really big problem. So to me, that institution disregarding that rim, just bouncing everywhere, that was gross negligence in my opinion. Like I said, nobody's getting sued, there's no lawsuit involved, but that's an example. It's something that, man, that could really lead to an injury, like a bad injury, and nothing was done about it. That was one of those situations. Once again, thankful nothing happened, but it wasn't good. And we started the second half of our game 30 minutes late because they had to replace the rim. And so this is intentionally, so then we also have willful and wanton misconduct, intentionally doing or omitting to do something with the knowledge that such action or inaction will result in harm another individual with a disregard for the consequences. So intentionally fail to prevent harm. That example that I just provided could easily be one of these. And so, like I said, these are pretty similar. I don't think I ever give you a case and ask you, which one is it? I expect you to know both of those terms, and I think the question on the test involves both of these terms. So you'll need to know that both of these are types of negligence and very intense types of negligence. This case is really funny. This is one of the first cases where we had the question of, is football too violent? Now we hear that stuff all the time with concussion protocol, launching, targeting, all these terms that are common to us now. This was one of the first cases. And Hackbart basically had an issue with the fact, is this play that occurred, is it outside the lines of football? Is it indeed too violent? That's what was in question. And so that's one of our first cases. Now that's something that we regularly discuss with football, but this is one of the first issues. So proximate cause, this is one I told you a couple slides ago, we're going to talk about it. So proximate cause, I think it's best to look at this is in an example. So if this is really important for you PE teachers. So if something goes wrong in your PE class and a parent gets mad and they want to file a lawsuit, they're probably going to sue you, your principal, your administration, your superintendent, etc. They're going to sue a lot of people. Sometimes they may actually skip over you and go straight to the administration to sue. So this is one of those things that makes that valid because the superintendent is responsible for the elementary school administration, and the elementary school administration is responsible for you as a PE teacher. So if you mess up, it's not just on you, it's also on your superiors because of their proximity to you. All right, so this is one of those. So if you want to go into administration, just be aware of that. Sometimes you get blamed for things that you didn't even do because it's your job to prepare your people below you as much as you possibly can. So be aware of that. That's the best example I can think of for proximate cause. I think that's a better way of explaining it than all these words, but read those two. And then damages, we use that term. So damages is what the plaintiff needs to have a case. So if nothing actually happened, if they didn't lose anything, whether that be physically, financially, etc., then we don't have an issue. Now, I would say that, your feeling getting hurt doesn't count as damages, but in some cases it does. But most of the time you need physical evidence. But sometimes you can get away with the emotional front. Some people are suing the NFL for emotional distress at the moment. That's an actual thing. So with this we have nominal, compensatory, and punitive. These are your main ones that you're going to hear about. Those are the ones that become a little more public. So this one's no economic harm has been done. They may just cover the cost of something minor, like maybe there's an injury, they'll cover the cost of a doctor's visit or something like that. This one is something went wrong and there's an injury and maybe they can't work anymore. So there will be there'll be financial compensation to make up for that physical injury. So sometimes nominal, maybe they cover the cost of a doctor's visit, but there's no actual, nobody's given money. But this one, it's so bad that maybe they can't go back to work and they lose those wages or lose potential wages. And so there's compensation involved. Sometimes when professional athletes get injured, they will actually sue for that and loss of future wages, or if a college player gets injured, they'll sue for loss of future wages because they are expected to have this crazy high draft pick and they would have $1 gazillion signing bonus. And so compensatory involves that. And then punitive, this is where you don't just have to pay up, but you have to serve jail time, community service, things like that. So those are your three options. Sorry for the struggle explaining. Nominal, my bad. So in this next section, I'll show you. Okay, so it breaks down each of these parties. So each of you in this class can probably fit yourself into one of those 5 or 6 molds that were available. So you need to think about, if you're going to be a coach, you need to think about what your responsibilities are, like supervising a locker room. If you coach high school, please, please, please supervise your locker room. That's one of the #1 ways that high school coaches get in trouble are for things that happen in the locker room or the weight room, and they're just not paying attention. So just pay attention. Be aware when you're traveling. Make sure to travel with your team. Yes, you also have a duty to provide emergency care. You don't need to be able to do open heart surgery, but you need to be able to do CPR. You need to know how to work an AED. You need to be able to tape ankles. Okay, those are responsibilities that you need to be able to do. And then duty to supervise, and then obviously as a coach you have a duty to be knowledgeable of your sport, things like that. The next few slides will go into administration. So they're responsible for overseeing transportation and knowing when it's safe to travel, and consulting with coaches and making sure forms are in and physicals are done. And then you get into your PT, AT people and team physicians. It's their job to decide whether a player can go back on the court or on the field. Is it safe? Is it wise for them? And if they do let them go maybe before they're ready, they need to make sure that that athlete knows the risk involved. So there's a lot of different duties, a lot of different responsibilities, and these are just a kind of a list and of all the liabilities. Obviously, I want you to read all of the book, but definitely, if you want to be a future coach, please read the liabilities of a coach section. It makes you think. Even though I've been coaching for a super long time, me reading that chapter for the first time made me think about some things. So please do that. Whether you're reffing. Some of you guys, great job in college. If you're not playing sports, go be a ref. Look at some of that stuff. That's a good way to make money. Work evenings, got school in the morning. It's a good option. I know plenty of people in this class want to be administrators. Make sure you read the section on administrators, okay? So there's a lot of things that can go wrong in sports. It's a fun industry to work in, but you really got to be aware because you're working with so many people. There's a high chance of injury. There's a high chance of conflict. So you've got to be aware of this stuff. It's so critical, all right? So there's a quick run of chapter 2 for you, and I think that's all I need to tell you.